All rise. Turn this court back in session. You may be seated. We're here today for a special series. Matthew Reardon, is he present?
Yes, Your Honor.
Prosecutor. Before we proceed, I want to make sure that certain rules are followed. Rule 1.03, the use of cameras, recording, or broadcasting equipment, or such shall be governed by the Code of Judicial Conduct. A couple of years ago, the law was changed as far as recording in courts. The bigger courts are allowed to record. So the Justice Court Rule 1.03, cameras or recorded devices still not allowed in justice courts or municipal courts. So, Mr. Reardon, I want to make sure that you understand there shall be no recording of this.
Your Honor, I had questions about that. I had questions about that, Your Honor. It's my understanding Justice Court...
It shall not be permitted.
Okay.
As far as a recording device, camera, or anything as far as this hearing is concerned, it shall not be allowed.
Can I put a motion before the court for that?
Mr. Reardon, the motion. That is the rule governing the Justice Court. We're not going to have it recorded. Are you recording this hearing?
I've got my cell phone recording, yes, sir.
Mr. Constable, will you make sure it is? Yes, sir. No.
Okay. Leave it out here still on my camera.
Mr. Reardon, you have made a motion before this court, a motion to dismiss with prejudice.
Yes, Your Honor.
Would you please explain your motion?
Well, Your Honor, I had, after the arrest, approximately, it was within 2 weeks after that, I put in a motion for, actually it was a subpoena Deuces Tecum. My reason for such was that I reached out to the Lafayette County attorney, David O'Donnell, for guidance as to whether or not the county was going to cooperate with a discovery request for the information that I was seeking. In particular, each camera that viewed the parking lot of the Lafayette County Sheriff's Department. I also wanted the booking area of the jail where I was restrained for upwards of an hour upon being brought in, as well as held an additional day to speak to the sheriff. And I was denied the information that I was seeking on the subpoena Deuces Tecum. The prosecution actually got to pick and choose what they wanted me to see, which was one camera scope, one camera angle, and just slowing the tape down, zooming in. There were quite some disturbing finds on that video that definitely warrant the additional angles.
Mr. Reardon, I understand you represent yourself. I would say, are you familiar with Mississippi Rules Criminal Procedure 17.10?
Somewhat, Your Honor.
Anything else you wish to add to your motion?
Other than I have the right to a fair and impartial trial, and this is the entire time over the last 3.5 years. It's been nothing more than just a targeting witch hunt, Your Honor. I would just like to get fair treatment. That's all I've sought. In fact, this charge stems from me just seeking out to the sheriff, reaching out to the sheriff, trying to get the equal protections under the laws after I was targeted by my ex-girlfriend on a false charge.
The prosecutor?
Yes, Your Honor. I'm familiar with the rules cited, Rule 1710, discovery in municipal and justice courts. Of course, for the court's record, I need to bring it up. That was the nature of my response to this subpoena Deuces Tecum, and that's the not an unusual item that I see quite frequently is subpoena versus tickle. And I've debated that with lawyers involved as well, so, you've got this discovery rule. And if you read it, a fair reading of that discovery rule, and I've had other prosecutors that I've debated this, a fair reading of that rule requires me and a prosecutor similarly situated to provide, a few items. For those few items, and it's always been required based on Supreme Court rulings in the past. All of us guys in that situation take that seriously. That if there's something in there that we know that's exculpatory, that means it proves that the defendant did not do it. I'm supposed to give that up regardless if I get a request or not. And I attempt to do that. Sometimes I don't have that information. But as you can see, that's set out in Rule 7-10. It's codified based upon the trial rulings. Copy of any exculpatory material concerning the defendant. Which in this provide analysis, what I'm to provide is, so there's no trial by ambush. If the names of all witnesses expected to testify, and that's an important word, expected to testify for the prosecution. So I typically say, direct the police department, give them the report. That identifies everybody that was there. And I'm under a continuing duty to identify anybody else. But that's in there, the deputies that were there that day are there. Of course, and that's all the ones expected to testify. Number two, a copy of a written statement of the defendant. Written statement of the defendant. Some lawyers, some defense lawyers, they take the carry time with the written statements of the victim. They're not. I try to educate them on that, but only if the defendant is given a statement. So somewhere in there, if they had gave a statement, one of those that was, their own free will on the board, and perhaps Brandeis or not, and just see where they are. In this instance, we don't have a written statement of Mr. Reardon. Copy of criminal record of the defendant is proposed to be used for impeachment. It's my understanding Mr. Reardon got somewhat of a criminal record. I'm not intending to use that by way of impeachment, or I have not considered that, so I'm not going to provide that. And I guess the censure there is I can't use it at this point if I don't get it. It's not that the case being dismissed. I can't bring up this criminal record. Copy of the laboratory reports or reports of any test made. This instance, that usually comes up in the realm of the DUI. In this instance, don't have that. Number 5, and this is what I try to comply with when he accuses me, picking and choosing what angle. Only got one angle, John. Copies, any physical evidence, photographs, and/or electronic data to be offered into evidence. There's another important words in there too. To be offered into evidence. If they exist, and I don't intend to offer them, I don't have to give them up. But I read that. I say, out of fairness, I'm going to give the guy. If I know that we've got a video out there, photographs, and give him. Of course, I've given him photographs of himself as well as that video from the camera out in front of the jail. Affidavit became search warrant. No search warrant. And then the prosecution's under continuing to supplementing disclosure previously charged. Obviously, if I discover something, I definitely give that to them. Exculpatory matters, grade material, if you will. So that's my response as it relates to the motion to dismiss and transfer. Obviously, I've done exactly what, and these rules were promulgated by the Supreme Court comments, and it took them 3, 4, 5 years to come up with these things, and they've only recently come into being. And they were all rules that we really abided by, but it was case law. They just codified case law in the civil years to practice here. As it relates to some of these other items, as he asked for, and this is speaking, and this is where rule number 33 comes into play. He asked for police reports, incident reports, arrest reports, other internal records for the last 7 years. in my opinion, as relates to this case, those are irrelevant. All interior cameras reporting equipment showing the booking area, that's a safety concern. It's my understanding Sheriff's Department never releases those information just for cost of what might go on and sensitive nature, who's in the part of the jail. All interior cameras reporting showing the booking area, the jails, road, holding cells for December 3rd. Again, those items, in addition to the security issue, they're also there for a relevancy issue. Everything that led to the arrest of Mr. Reardon occurred on the outside of the Sheriff's Department. And that's depicted on that video that was supplied sometime ago. So I think it's his motion for dismissal or his alternative transfer. He's complaining that I've done exactly what the rules dictate to me, that are required of me. There's rule, citing back to Rule 33, if you want a subpoena, just keep them at cross for production of documents. The first things you got to do, the one you can't ask that those be delivered to you at some time prior to a hearing without court approval and order. And then there's a process for that, Sean. None of that has been done to this point, even after educating what that Rule 33 exists as relates to Mr. Reardon. Number 3 of Rule 33, supporting affidavit or declaration of motion seeking, subpoena seeking shall be supported by an affidavit or declaration stating facts which establish the documents or items sought or evidentiary and relevant. Boundary are relevant. The document and not evidentiary as far as the charges as proper. The documents or items sought are not otherwise reasonably curable in advance of trial, hearing, or proceeding by exercising due diligence. Well, it's got things like that. He's got everything 1710 requires at this point that I'm aware of, and I've got to continue to do it. Moving property cannot properly prepare for trial without such productions and inspection in advance of trial, and the failure to gain inspection may tend unreasonably to delay the trial. Again, it's not relevant. And it's a safety issue. He's got to assert those things. I don't think we've seen that yet. The application is made in good faith. And here's the kicker. These words mean something in these rules. It's not intended for the purpose of general discovery. Discovery, he gets discovery in this criminal matter, what's dictated in 1710. For that reason, in those items sought, or in my opinion, why I filed a motion to quash, not discoverable and or outside what this court is going to deal with as relates to the criminal charge at present.
In response to that.
Yes, Your Honor. So, what Mr. Chain just showed off was typical.
Jack. If he wants to comment to the rules, he can do. He doesn't get to personalize things. He can talk to the tribunal. I object to anything that's extemporaneous as relates to that. If he wants to argue the state of the law, let him be a lawyer and argue the state of the law.
I'm not trying.
We're going to keep it on the point.
Yeah, he's going to tell me, I'm not trained to be a lawyer. Well, it's his choice. Anybody in this country can act pro se, but they're held to the same standard as a lawyer. These books they're on the internet.
Why can the same standard not be applied across the board evenly when it comes to anything with Lafayette County? Because that's the whole reason we're here right now, Your Honor.
Mr. Berry, let me stop you there. We're not going to get into anything in the past or what happened. I'm here for a motion before this court on a case that is scheduled to be tried March 22nd.
Yes.
That is what we're here about. As far as any conspiracy or anything like that,
There's a federal lawsuit filed.
don't want to hear that. I'm here for this motion before the court of the discovery request you have made. You've heard what the prosecutor said. Do you have anything you wish to add to that?
I do, Your Honor. I mean, you have my car being searched by 8 sheriff's deputies.
Let me stop you there. We're not going to try a case today. You have made a motion before this court as far as your subpoena, as far as discovery is concerned. That is what we're here about.
Your Honor, my rights basically can get trampled on and you not have any kind of recourse.
You're right,
not
I'm
being able to
being
get.
done in this court. You're talking about something in the past. We're not here to determine about something that's happened in the past. We're here to determine about 2 charges that was filed against you that comes to trial March the 22nd, correct?
Yes.
That is disorderly conduct and
And Your Honor, I have not tried to delay it. In fact, I've tried to actually speed it up. All I'm simply asking for is the camera that's closest to where the incident actually occurred, which is right in front of Sheriff Joey's vehicle, which was right in front of my vehicle. It got a different vantage point, and that was specifically the camera that I really wanted to have access to. And I don't think it's asking too much to get the closest camera to where the incident actually occurred in the parking lot.
you're also asking for a transfer.
Well, actually, Your Honor, that was addressed. There was a new renewed motion there was a motion to dismiss or the alternative to compel the prosecution to comply with the subpoena we suspended.
They say, the prosecutor, you get the last vote.
Plenty about the standards, Stephen, obviously, we're based upon dates. Where are we? You said that will become moving, or?
I believe we actually had 2 motions. I believe this may be the motion you're looking for. I believe the first motion was actually asking for the transfer.
And Your Honor, I meant to introduce this. I have a motion for discovery right here for anything that was not included.
I've got it based on the rules, but I've given you everything. That's the spring conversation. So I mean, don't know where we are on that as relates to these other information. Rule 33 requires that you tell us why he wants these things, why they're relevant.
I think I've done that.
Not relevant, you know. And it's seeking discovery for both other matters and other courts. For those courts, in those matters, likewise, have a set of rules of their own. There's FOIA requests, freedom of information requests. The criminal side never sees. Don't know what that's don't know how.
Objection, Your Honor.
The prosecutor has the right to speak at this time.
And, that's where we are. If he's seeking discovery for federal court suits, there's a process to seek or discover items in that process. But not in the prosecution of him as it relates to the events that occurred on 21 March or occurred back in 28 December.
Maybe say it. This court is here today not to relive anything that's happened in the past. We're here to hear a motion that has been presented to this court as far as the motion for discovery, and has discovery been provided. Mr. Reardon, we're a country and state of laws.
Yes, Your Honor, we are.
I'm a firm believer for a fair and independent judicial system. And in simple layman's terms, you have been provided discovery as far as what is required to go to trial March 22nd.
But what is the county trying to hide so bad with the closest
Mr. Reardon, if you keep on interrupting this court, and you will be held in contempt,
Yes,
and you
sir.
will go to jail. I will not be interrupted again. Do you understand that?
Sorry, Your Honor.
As far as the motion to transfer, this court is a fair and just court that will determine this case on the facts presented in the courtroom March 22nd. As far as your motion to dismiss this case, the motion is denied. Discovery request has been provided to you. We are governed by the Mississippi Rules of Criminal Procedure, Rule 1710, also Rule, which the prosecutor said, Rule 33. I'm sitting here looking at the rules of discovery. The rules of discovery has been met by the prosecution. This will be heard on March 22nd at 9 o'clock. Motion denied. Court adjourned.
I'll move when I talk to Joey. Joey knows I'm out here waiting. He needs to come out and talk to me. I'll move when I talk to Joey. When Joey wants to talk to me, I'll move. Otherwise, I'm not breaking any law just for parking in a spot that says reserved for the sheriff's department. I'm here at the sheriff's department.
You will go to jail for disorder.
I'm not being disorderly. I'm moving my car! I'm moving my car! I'm moving my car! Ah! Really? Ah! I'm moving my car! Oh! Ah! Ah! They told me I couldn't afford once it started. And turned off the iPhone XS. Yeah, kept the tape recorder going. Great plan. It's funny how Lafayette County wants to treat him. How they apply the rules. They go by equality when it's anything, where it disadvantages me. But then again, when the shoe's on the other foot, this is everything but just typical. And I even said, whenever I was on the cross with Jay Chain, I said, Mr. Chain, may be referring to a typical scenario, a typical case. This is everything but typical. This is, what is it that Lafayette County is trying so badly to hide and to cover up? Their obstructionist tactics. The camera that is closest to where everything occurred. The camera closest, when there were already several bizarre things that were captured on video, especially when slowed down. And the camera angle that's the closest to everything, that sees everything from a different standpoint. They will not comply with, nor the camera inside, the booking area of the jail. And, Judge Avent refused to freaking entertain my argument. And he wanted to say whatever conspiracy outside of here. I was like, it's not a conspiracy. The things that I've brought forth are things based on fact. That's the reason why I've asked for them. It's these obstructionist clowns that are keeping that stuff back. They're trying to cover it up, and they want to label it as I'm freaking fishing conspiracies. No. It's my life that got destroyed based on all these, all the shenanigans that happened in Lafayette County. And now you got a unlawful search and seizure with 8 different sheriff's deputies in my car. And you have what would easily appear to be a highly unlawful arrest. He wouldn't let me introduce evidence. I slapped a motion for discovery on the table and said, I'd like to enter this to cover anything that had not been given to me off of the subpoena ducis tecum and re-raise the subpoena ducis tecum. Because there's camera angle, it would only make sense for me to get the closest camera to where everything happened. That's what only makes sense. Why would you give me a camera from further away? And whenever I've already asserted certain claims, and you know, why would you? I'm at the gas pump, by the way. Why would you refuse? Why would you refuse to give me the closest camera? No, it's not trial. Like, so that was a hearing. That was a specially called hearing on my motions. Normally they don't do that because I kept on fucking giving it hell. He held a special hearing. He held a special hearing on my motions to determine if there was grounds to dismiss or transfer it to another jurisdiction. And now I'm thinking about doing a motion to recuse. And that way, at least everything is on paper, so I can always do an appeal to the Supreme Court. And if everything is on paper in motions and filings, it'll be easy for it to go to the Supreme Court, and the Supreme Court be able to see everything laid out and see that I was completely ignored.